Because I feel like it's a season of baby Jesus. I want to give you much to in your life.
I feel like
I don't know. No, seriously. You can't touch it. All right, the court is calling 2024 CR 0787 State versus Nashia Harrison. Could I have parties announced for the record for the state?
Lawrence knows for the state.
And Mr. Cortez, if you could unmute and start your video, please.
Yes, Your Honor, this is Fernando Cortez for Ms. Harrison.
And are you Ms. Harrison?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Is there an application for probation?
Yes, Your Honor.
All right. Ms. Harrison, did you review the application for community supervision or deferred adjudication with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
State moves to waive the punishment in hate.
Any objections?
No, Your Honor, no objections.
All right, and Yaya, if you can give me the indictment, please. All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, thank you. The state is proceeding on the offense of possession of a controlled substance. Penalty group 1. 4 to 200 grams. Let's go off the record for a moment. All right, counsel, this is possession. All right. So did you understand that the state is proceeding on a possession of a controlled substance, penalty group 1, 4 to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Harrison, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 7 years in the prison. There's a $1,000 fine. The state is opposed to your application. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense, as charged, how you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
State offers states exhibit 1 and all attachments.
Any objections?
No objections, Your Honor.
You reviewed the waiver and stipulations with your attorney. Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt. Counsel, if you want, this can be recalled back in 12 weeks for sentencing if you're requesting a PSI and a top evaluation, or if you want it done sooner, we can have it back in approximately 2 weeks, and you can call whatever witnesses you wish to call. Which do you prefer?
I would like the TAP evaluation, Your Honor, please.
All right, I need a date for PSI and TAP, please. All right, we'll bring you back on February 3rd. On February 3rd, I'll make a decision based upon whatever evidence is presented to me.
Okay,
All right, good luck to you.
thank you.
You're welcome. Yes.
Your Honor, I have an unrelated discussion.
All right, Raymond Diaz. Who's the attorney for Raymond Diaz?
That's me, Your Honor, Daniel De La Garza.
You may be excused. Let me find. Norma, what page is Diaz on? Thank you. Just one moment. Odyssey is a little slow, counselors. Just give me a moment. Sorry. All right, so on Mr. Diaz, defense, did you provide a drive for the state and state, were you able to turn over the CPS records, and is the discovery completed?
Your Honor, the CPS records are uploaded and able to be accessed by defense, although I don't know if they have issues with the e-discovery system like some defense attorneys.
Any issues with e-discovery?
Me, Your Honor?
Any issues with e-discovery for the attorney for Mr. Diaz?
No, I don't have any issues. No, I can access it.
All right, and state, were you able to tender an offer?
Your Honor, I know that Mr. De La Garza and I do confer regularly. We've got several cases together, so although today we have not, I will.
All right, Ms. Ferguson, if you can set this for a plea deadline date in January, you all need to confer off docket to receive your plea. And then Mr. Diaz, if you decide to have a jury trial, it will have to be in the new year. What date? All right, January 12th will be your plea deadline date. At that time, you'll need to let the court know whether or not you reached an agreement with the state. If you have not, your next setting will be a jury trial date. All right, thank you.
Thank
All
you.
right, thank you. Eric Cepeda?
Also here on that one, Your Honor, Mr. Bunk.
Yes,
I'm
ma'am.
here.
Yes, ma'am.
All right, Mr. Cepeda, if you'll show your video.
Hey, Eric.
Hello. Hello.
How do you see everybody? I can't see everybody. Oh, shit.
All right, so I'm getting a lot of feedback. All right, so on Mr. Cepeda, where are we on discovery?
We have the discovery, Your Honor.
Okay.
Well, let me back up. We have all the available discovery in discussing this case off docket with Ms. Alban. I've
I'm here.
discovered that there is some outstanding, or maybe a DNA test that's still yet to be conducted. So we are set on a plea deadline today, but I would ask that we come back for another plea deadline date so I can see the results and Mr. Bunk and I can review the results of that DNA.
All right, Norma, if you'll set this as a plea deadline date the same time as Mr. Diaz, please. All right, so that will be January 12th. There will be no further extensions of the plea deadline date. If an agreement is not reached at that time, then your next setting will be a jury trial date.
Okay.
Your Honor, sorry.
Yes.
Oh, I'm sorry. I'm on the elevator, so I wasn't sure if you could hear me. Mr. Cepeda is the co-defendant with Dorian Camarillo and Robert Monreal. And Dorian Camarillo's plea deadline date was set for February 26th. So I didn't know if you would want to set all of them at the same time.
Ms.
And Judge,
Ferguson,
and I would, yeah, okay.
and what were you saying, Mr. De La Garza?
Just that I would join in that request. Just it gives us more time and it lets the DNA. You know how the crime labs get kind of backed up. It gives more time for the crime lab to get it to get at the
What
result.
date did you say it was, Melissa?
Yes, ma'am. Dorian Camarillo was set for February 26th for a discovery check-in, I guess.
February 26th is your plea deadline date.
Well,
Okay,
Your Honor, you know, if he's also on a discovery deadline, can we be on that track as
Now,
well?
if you have your DNA before that date, then that's going to be your plea deadline date.
And I
they
am
have-
going, I'm sorry.
They have other discovery issues that are not the same discovery issues that you have.
Well, but the concern is that then I want that stuff because they're all co-defendants and I would want whatever issues they have. I want to know about them and I want the rest of that stuff.
And I was just going to say, I am going off of memory because as you know, I'm on my way to an appointment. So I would guess I would confirm with Norma if I'm correct, if it was discovery or a plea deadline. I could be mistaken.
This is what you all are going to do. You're all going to come back on Friday. See you then. And everyone needs to be in person. So
Well,
I'll
Judge,
see you on Friday.
I'm out of town on that day and I have a vacation letter. I actually have one for today too. So I'm not available on that day.
Mr. Blanc, are you going to be here on Friday? Oh, I'm sorry, you're muted.
Yes, Judge, I can be there on Friday.
All right, if you'll come by on Friday, Mr. Blanc.
Yes, ma'am.
All right, thank you.
Thank you. Thank you.
Yes. This is what happens when you have 30 people on. Nobody has their camera on. And of course, I'm exaggerating with 30 people, but all right, Norma, put that for Friday the 12th. Oh, Friday is the 5th, correct? Yeah, the dates are flying. All right, yes, put it on the 5th, please. All right, let's bring the jurors in. All right, thank you so much.
There's gonna be on a panel. There's gonna be a.
Yes. Oh, yeah.
You know how to set it up.
Yeah. Yes.
No.
Oh, yes, I do.
No, it's cool.
Taking at their time is easier.
Oh, let me give you this, Norma. Oh, yeah, yeah. Thank you, yeah, yeah. What's the name of that movie? Something, it's a book, it's a series, The Horrible Bad Day or whatever. The title of it is A Horrible Bad Day. It's where this child has a horrible day. I don't remember the name of it because I got it for my niece. Oh, Cindy, it's the Horrible, Terrible Day book. And then they have a series. The next one is The Horrible, Terrible, Very Bad Day. And it just goes on and on. All right, everyone, please be seated. And ladies and gentlemen, we're starting late because, believe it or not, I have a docket that includes this jury trial as well. So that's why it took us a little bit longer to straighten out some paperwork. And sometimes technical things happen that we have no control over it. So I do appreciate your patience. So before I turn it over to the state and the defense, who each will have 20 minutes to speak to you, I'm going to tell you two stories, and both of these stories are true. The first story, we're missing one in the restroom. Oh, okay. All right. So here's the first story. Number one, I always tell jurors that jury duty is an inconvenience. It is not a sacrifice. Why is it an inconvenience? One, because you have to wait on the court. Two, you have to find parking. Three, you have to find out where you're going, and the signs are not as they should be. And when I see you all running, I always tell you, slow down. You're like, no, but I need to be here at 8 a.m. And you sit downstairs and you wait. You come outside and you wait. It's an inconvenience because your country only asks two things of you. They ask for you to pay your taxes and serve as a juror once in a blue moon. Raise your card if you have ever served on a jury trial where you actually sat and listened to evidence. Oh my gosh, usually we don't have that. Let me take these numbers down. So that's 11, 14, 22, 19, 20, 21, 24. When I call your number, you can lower it. 30, 31, 33, 28, 36, 38, 39, 40, 44, 54, 57, 64, 70, 71, and 74. Of those who raised your card, how many of you sat on a jury and were able to reach a verdict? All right, that will be 11, 19, 14, 20, 22, 28, 31, 33, 36, 39, 40, 44, 54, 64, 57, 70, and 74. Of you who reached a verdict, how many of you were on a criminal trial? That's 11, 19, 20, 31, 36, 39, 44, 54, 64, and 74. Of those that were on a criminal trial, how many of those cases were in Bexar County, Texas? That's 11, 19, 20, 39, 31, 36, and 64. So 44, 54, and 74, your verdict was not in Bexar County, is that correct? 44, please stand. Was your verdict in Bexar County? What county? All right, thank you. Number 54. And where was your verdict? Thank you. And number 74, where was your verdict?
It was Reese Air Force Base in Lubbock.
All right, thank you. Now, of those who raised your hand and said that you have served on a jury before, how many of you all have served on a jury more than once? That's 19, 20, 22, 30, 33, 44, and 64. So as you can tell, that's still not a lot of people in this group who have actually served on a jury before. So what does that mean? That means that your government does not even ask you to serve once every 3 months. You're called up once in the blue moon. So I tell people that's an inconvenience. I always see people on 4th of July, Veterans Day, Memorial Day, people always want to put flags out. You can serve your country by serving on a jury. We cannot have jury trials unless we have jurors. This is a sacrifice. My family grew up in a place called Grand Canyon, Louisiana. You can always tell usually where I'm from when I have to say words like oil and soil. You can tell I'm not from here originally. I'm from Louisiana. Well, when he started school, that was back in the day where the teachers not only knew every child in their classroom, they knew every child in the school, and they knew all the parents. They knew who to go to if you were doing something you were not supposed to do. And so they would tell my grandmother, they would say, Miss Lane, we've taught him all we can teach him, and they would pass him to the next grade. When his sisters and brother ended up being in the school as well, they were a little bit upset with him, as you can imagine, because all the teachers told them, this is the gold standard. You had better show us something. So fast forward, he graduates, and there's a conflict that breaks out called the Vietnam War. He goes to my grandmother and he tells my grandmother, look, there's not much I can do with civil rights. I can't improve my lot in life. And so my grandmother signs for her firstborn child to go off to Vietnam. Now, let me take you back to that time period because we're used to certain technology today. Number one, she had a television set. It had 3 stations, ABC, CBS, and NBC. You really couldn't count on NBC because if there was a breeze, it was not going to work well. And the way people are saying, oh, I have insomnia, I stayed up all night watching television, but there's so much on, it's the same thing over 200 channels. Didn't have that. At a certain time, programming ended. And when programming ended, you would know it was going to end because the national anthem would play and you would have a flag blowing in the wind, and that's the end, and you wait for the next day. My grandmother did have a phone, but her phone did not have numbers. The people who are my rotary people, you know what that is because you can tell who used a rotary phone by their index finger when you were trying to win the prize from the radio station. And you thought your family was wealthy when you finally got a phone that had the redial button on it. Still didn't win though. So you would pick up the phone, the operator would answer, and you would tell them who you wanted to call. That's why they would have songs like Beechwood 45789. If my grandmother were alive, she would be shocked that you can pick up a cell phone, take a photo, send it to someone, that you can video with somebody and let them see it. So all she had was my uncle's name and the address to send his mail. And what I can tell you is a lot of the males in my family are in the military. So they still do the same thing they do today. When your boots hit the ground, you need to write a letter home to let them know that you've arrived safely. My grandmother had a 6th grade education, but she was super intelligent. She babysat me, taught me how to read, write, tell time on that clock, not the digital thing that we have now. And so she sends him off and she writes letters and she just waits. I would always end that story there. Then Deputy Laura said, Judge, what happened to your uncle? Did he make it back? My uncle did end up being shot, but he did make it back. And to this day, he's since passed, but to this day, whenever I smell Old Spice, it reminds me of him because that's what all the people in the military would wear. And he would come home. I would go up to him, hug him, and you could smell the Old Spice, and he would always bring gifts. So I always tell people that's what a sacrifice is. Sending your firstborn off, having no idea if they're going to come back or not. Now, the second story I'm going to tell you is about one of my friends from law school. They were called up for jury duty and they said, let's have lunch. I've been called up for jury duty. I said, great. We're eating lunch. I'm asking them, how is jury selection going? They said, fabulous. Now that I'm a judge, how can it be fabulous? It's not with me, right? And so I said, why is it fabulous? And she said, Stephanie, I'm not going to be selected. It's just like in law school. I'm on the back row, keeping my head down. I started laughing. She said, what's so funny? I said, I'm happy. She said, why? I said, because we're going to be able to have lunch all week. So other than raising your hand and saying, please place me on this jury, the quickest way to be on a jury is not saying anything at all. And I tell you that because one, it's true. And two, both sides only have 20 minutes to talk to you. They don't have the luxury of going to your house, having dinner with you, and really getting to know you. This is the only time they get to know you. So please answer their questions and don't be shy. Every answer that you give is the correct answer. State, are you ready to proceed?
May I have a second to give-
Yes. And would you like a time announcement?
Maybe 2-minute warning?
Okay.
Thank you, Your Honor. May I proceed?
Yes.
Good afternoon, everyone. Thank you so much for your attendance. I know it's late in the day, but I very much appreciate y'all being here. As I mentioned, my name is Rick Pena, and I'm a prosecutor of the DA's office. This is my trial partner, Patrick Jones, and that is Mr. Diego Sanchez in the back as well. Now, raise your hand if you're excited as I am to be here right now. Oh, I got 2 new best friends right here. Okay, thank you. Sometimes I've never had anybody raise their hand because I get it like the judge says. Jury duty is an inconvenience. It's like having to go to the dentist, right? Who likes actually getting a jury summons in the mail? Okay. So I promise I'm gonna try my best to make this as painless as possible for everyone. But like the judge was alluding to earlier, there's a saying that goes around with jury selection. If you talk, you walk out the door and you go on about your day and go home, okay? If you're quiet, you end up having to sit over here and be on the jury, okay? So I encourage all of you, participate with me, participate with Mr. Greehey when he gets up. If your chances of going home today, I'll tell you much better. Now, as you can see on the screen, we're here for the state of Texas versus Mr. Duran Evans. The offense that he is currently charged with is assault family household member impede breath or circulation. What the heck does that mean? We'll get into it, some of which I can get into, a lot of which I cannot get into as far as the specific facts of what happened. Those lucky 12 of you that get selected to sit over there will hear about all that. What I'm going to cover right now is mainly going to be about the law associated with that particular charge. Okay. Let's see. It's not working. It's all right. Okay, one has to do it like this for now. All right, who feels like that right now? I promise I'm not as angry as I look. Okay, so. Is it working? Yeah, okay. Okay, so that's that. So, there we go. Jury selection is basically a few quick things I wanted to do is, again, I cannot talk to you all about the facts. There are no right or wrong answers to any question that I may ask of you, or that Mr. Beacon may ask of you. We just ask that you please be honest with all of us, okay? And again, like it says, underline, participate, your chances of going home are much, much better. Here are the goals of what we're here for today is to talk about the law. I want to learn a little bit about each of you as best I can because we're all 75 new best friends, right? And the goal ultimately is to find 12 fairest and most impartial jurors that we can get for this particular type of charge. Or for this case, excuse me. So let me explain to you kind of what that means. Being here in the great city of San Antonio, I would hope that everybody here is a Spurs fan. Is that correct? Thank you. Does everybody then know who Greg Popovich is?
Yeah.
Excellent. All right, so let me give you a little hypothetical. Well, not really hypothetical. Tell you a little story about my brother. Huge sports fan. I'm a huge sports fan, but I think he beats me out. When it comes to merchandise, news, he's glued to the TV for all the games. It seems to me like he gets there before the public gets there about what's going on with the Spurs. He is a diehard Spurs fan, okay? So, as I mentioned, everybody knows who Greg Popovich is. If Greg Popovich, not that he ever would, greatest coach in NBA history, in my opinion, but let's just say he shot someone. And then he walks over to a camera, what's this? Says, I'm Greg Popovich. Here's my date of birth, here's my social, here's my phone number, here's my address. I just shot this person right here. Now, being that my brother is as diehard of a Spurs fan as he is, I can almost promise you that he would think that's a fake video. Do you think my brother should be on Greg Popovich's jury?
No.
Excellent. That's an example of what is not a fair and impartial jury. He's really for Greg Popovich. We're looking for people that are going to be fair to both sides. Okay. So let's talk about this particular charge right here. Adult family household member impede breath circulation. That right there is what the law says we have to prove to you all today, or throughout the course of this trial, excuse me. In order for this crime to be proved beyond reasonable doubt, we have to prove that on or about a certain day here in Bexar County, Texas, this defendant right here, either intentionally, knowingly, or recklessly impede the breath, the normal breathing or circulation of blood of a complainant. I'll get you 1 second, sorry, I see you. By applying pressure to the person's throat or neck. Yes, sir. Number 4, you got a question? I'll explain. Sure. Thank you. Before I do, does everyone understand intentionally or knowingly? Any questions about those two? Okay, so recklessly, let's explain what recklessly is. All right, here's a silly example. Everybody's got their lucky things, right? Some people are their lucky socks, their lucky jersey, whatever, right? Someone's got something that they're really passionate about. But I'm a weirdo and I have a lucky chain. And I think that, me having this chain is going to bring me some good luck with this trial today. So I'm having my chain right here. And what's even more weird about it is I think that maybe swinging it around is going to even give me more good luck. So I'm walking around my chain, swinging it. And as I pass by juror number 19, I hit her in the face with it. I break her nose. Now, did I intend to do that to juror number 19? Did I know that I'm going to do that just by simply swinging the chain around? But that's pretty reckless for me to do it, especially around a big group of people, that I might cause injury to someone with something like that. Make sense? All right. So that's essentially what we can prove. And this isn't or, that you see on the screen, not and. So what that means is we're not required to prove all intentionally, knowingly, and recklessly. One of those three. It's either intentional, or it's knowing, or it's reckless. Make sense, everybody? Yeah. All right. Now, I'd like to next talk about this particular subject of what's called family violence. And I know some of you probably aren't familiar with it. but I'm assuming everyone here has heard the phrase domestic violence. Is that correct? All right. Here in Texas, that is referred to as family violence. Okay, so anything you know associated with domestic violence is family violence here in Texas, okay? So. Now I have a volunteer. You're 50. Actually, no, you're not over here, but if you want to, you can stand. Can you tell me why you think it is so important to prosecute family violence cases here in this state? Good, thank you. Anyone else have any other ideas they'd like to add to that? Can I have your juror 34? Yes, go ahead, please rise.
We're free to press charges against our back.
Very good, yes, thank you. Anyone else have anything else or agree? Juror number 10, or I'll get you a second. Yes, ma'am.
Retaliation for the other family members.
Okay, very good, thank you. And juror number 6. I apologize. Another family member, okay. Not to hurt another family member, okay, does that agree with? That was your number 6, yes. I'm sorry. Okay, does anyone else have, you're 18, yes, ma'am. So someone should have, right, you're 36, yes, sir. Protecting children. The children, yes.
All right, everyone, please remember to stand so that Cindy can hear and keep your voice up.
You're 26.
The last one was 36.
36, yes, was the last one, now we're at 26.
Aside from family,
I'm sorry,
to stop family cycle of violence.
stop the family cycle of violence. Okay, that's very good. Yes, thank you.
Okay, let me pause for a moment. Could I have the state in defense? All right, and counsel, I'll resume your time now.
Thank you, Your Honor. Those are all great examples. I appreciate your insight to that. So please keep all those things in mind when you're talking about this particular topic of family violence. Okay? Who are usually the victims associated in a family violence case? And juror 37, yes, ma'am. Could you please rise and speak? Okay, women and children, I think it's still same thing, okay. 35, yes?
Spouses, husband or wives.
Spouses, husbands or wives, 44, yes, ma'am. Elderly, okay, elderly parents, thank you. Anyone else? Juror 2, yes, ma'am.
I feel like honestly, it could be anybody in the family.
It could be anybody, exactly. Anybody who's in a family can potentially be a victim of any violence associated in the family. That's very good. Yes, thank you so much. Keep that in mind as well. Yes, juror 2 said that. Okay. Now, when it comes to these types of situations, myself, Mr. Greehey, we cannot pick the people that are involved, and we cannot pick the facts that are associated with what happened. So there may be things that you hear from either side that maybe you like or don't like. So my first question is, if you hear something about the victim of the matter that you don't like, are you automatically going to hold it against him? One, agree to disagree. So who are my ones agree that with that statement?
All right, let me pause. All right, ladies and gentlemen, remember how I instructed everyone that neither side can tell you what they think the facts of this case are? All right, so the terms that are being used on the screen are just to seek to educate. Is that correct, state in the defense?
Yes, Your Honor.
All right, so you may continue.
Thank you, Your Honor. Yes, I'm not talking specifically about this case. I'm talking like in general with these types of situations, victims. Okay, does that make sense so far to everybody? Okay, so in general, if you hear something about a victim of a family violence case, you would automatically hold it against them. Do I have anybody who agrees with that right now? Please raise their cards. Okay. I'm gonna go chronologically, juror 9, or juror 1. 17, 19, as I call you guys. 25, 30, 34, 41, 42, 43, 44, 50, 51, 69, and 72. Thank you so much for that. Okay. Now I'm assuming everybody else is on the other half of that as far as they disagree with that statement. Is that correct? Those other people that didn't hold up their cards. Thank you. Okay. Now let's talk about witnesses. Okay. Who can be around in these types of situations? Juror 42, yes, sir.
Oh, I'm sorry, could you speak up, please?
So,
Just 1 second. I'm gonna pause it. Could you hand him the microphone?
you're fine. With your response?
Like brothers and sisters, uncles.
What's your number? So that'd be other family members? Okay, do I see 37? Oh, I'm sorry. You answered? Okay. 71, yes, sir.
I would say anyone who is around when that event happens.
Juror 7? Friends of the family, yes, sir. Juror 14? Neighbors, 16? Anybody can be a witness, yes, 34. Respond, that's very good. Yes, essentially, like everybody's saying, there are a lot of examples, but anybody can be a witness to these types of things, okay? Now, you all, those lucky 12 of you, or unlucky, however you look at it, that end up getting to sit over here and listen to the facts of the case are going to be the sole judge of the credibility of those witnesses. Now, as I mentioned earlier, we don't pick the people involved in these situations. We don't pick the facts that are associated with these cases. But can everybody agree that we're going to listen to everything presented and make a decision after listening to all evidence presented? Is that a fair agreement we can render?
Yes.
Thank you. All right, let's talk about evidence. What types of evidence do you think that you might find in a charge of assault, family council member, people, the circulation? Someone will have me call on 27. Could you rise, please? I'm sorry, so the court reporter can hear you.
Any visible mark?
Visible marks, okay, yes. 53, I haven't called on you yet. Go ahead, ma'am.
Any videos or photographs?
Okay, and thank you, yes, 28, go ahead, yes, please rise.
Eyewitness.
Eyewitnesses, yes. 17, yes, sir.
I would say like, no emotion.
The person involved?
Yeah.
Okay, yeah, that's good, yes, sir. I think I was listening, yeah, okay, so 50, sorry, 8, go ahead, yes, ma'am.
Broken furniture?
Broken furniture, okay, if it's like in a household setting, you mean?
Yeah, maybe somebody got thrown against a piece of furniture.
Good example, yes, ma'am. 57, yes, ma'am.
I was just gonna say that it could also be any police report or witness information that was brought in.
Okay, I'm glad you brought that up. I understand. I'm gonna get you guys real quick. Hang on. I want to touch on what she just said right here. She said police reports. The general rule here in Texas when it comes to these types of cases is the lucky 12 of you that get over here and hear all the evidence, etc. One in general piece of evidence you are not going to be able to take back to the jury room with you to deliberate is the police report that's associated with the crime, okay? Unless there's gonna be some exceptional circumstances, which I'm not certain we'll get into on this matter, but generally speaking, you all are not gonna be able to take the police report back to the jury room. Now, knowing that, is there gonna be anyone who's gonna say, you know what? I cannot render a decision in this case if I do not review that police report. Does anybody feel that way? Okay, sure, let's start numerically.
Question, sorry.
Yes, I'm sorry if I couldn't hear. Did you hear what I was saying about police reports? Okay, so if you cannot take the police report back to the jury room with you and review it in order to make your decision, you're gonna be unable to render a decision in the case. You have to have that police report, is essentially the question. Is, okay, so let's start with who needs that police report? Go ahead and raise your card and we'll start numerically. 15, 16, and you can push your cards. Oh, thank you. 25, 21, thank you, ma'am. 32.
My question.
Sure.
Does this mean that we wouldn't have been able to get the evidence that is on the police report, or you're saying we can't actually take the physical copy, but we will know what's on?
Like you said, no, you're not gonna take the physical copy of the police report back to jury with you, but you will be presented with the evidence that is in the police report. Does that make sense to you? Yeah. Okay, so the prior people that I called, are you still on the same? Or you had your, okay, let's try it one more time. Knowing that, who needs that police report back in the jury room? And please raise your cards if you feel like. Okay. Juror 9, juror 10, juror 21, juror 6, 32, 38, 44, 45, 51, and 61. Thank you very much. Okay. So we did talk about, can't remember, I'm sorry, back here, who said pictures at one point, but if there are pictures and they do not show, I believe he said visible injury, right? If they do not show visible injury, is that going to be an issue for anybody? Okay, so there is a yes. Okay, all right. Let's do it again.
Yeah.
I'm sorry, I'm trying to move out so everybody can hear me. So one of the, go ahead and put your cards on for right now, and then we'll check this again. One of the juror 27 had mentioned that you can get markings right on your neck if you were potentially choked. Right? And sometimes there may or may not be pictures that show visible markings on your neck from being choked. If there are pictures that do not show any type of injury, is that going to be an issue for anybody? Does anyone need to absolutely see markings right here in order to determine for sure if somebody was choked? Okay, go ahead and leave your cards up and we'll take this one at a time. Juror 1, thank you, ma'am. 8, 9, 10, 11, 12, 7,
2
15,
minutes.
16, 17, 18, 19, 20, 21, 24, 25, 26, 28, 29, 32, 42, 38, 53, 57, 61, 69, 72, 73, and 74. And I only got 2 more minutes left, so I gotta kind of speed things up a little bit. But please consider the fact that testimony of people involved is evidence that you all should consider. Testimony is things that you hear from people on the witness stand over there, okay? Keep that in mind. Real quick, I want to explain beyond reasonable doubt, like the judge says, our great legislature has not provided a definition of what beyond reasonable doubt is. What I can tell you is not beyond all doubt, and it is not 100%. Now, the other thing I can say is that the best definition I can give you is that beyond reasonable doubt is what you all decide what it is, okay? With that in mind, who is going to hold us as the state of Texas to a higher standard than beyond reasonable doubt. Who wants beyond all doubt and 100% certainty in the clip is, that's fine. Please just let me know and raise your card. All right. 9, 12, 15, 16, 25, 28, and I'm sorry, ma'am.
Can you repeat it? I don't remember.
Sure. Mike. So beyond a reasonable doubt is essentially, it's not beyond all doubt. It is not 100% certainty. And I can tell you why is because none of us were there when it happened, right? We don't know what happened. We're gonna be told what happened by people over here. So nobody in this room can be 100% certain about what happened. With that in mind, is there anyone here who's gonna make us prove 100% certainty? And you know what, let me get to the next slide, I think it'll help. Who here's put a puzzle together? I know everybody probably has, right? All right. What is that a picture of? All the puzzle pieces put there. So I would like you all to consider that beyond a reasonable doubt is you're putting a puzzle together. Your puzzle pieces are your evidence. You don't have all pieces. You have enough though to know, in this case, what the picture is. In our case, you have enough to know whether or not an assault impeding breath took place.
Objected that he's given a definition of reasonable doubt as opposed to the slide says reasonable emphasis and filling in the gaps. So there is no legal definition of reasonable doubt. So I'm objecting to that, misleading to the jury. I think that the court can just clarify that for the panel.
All right, ladies and gentlemen, there's no definition of proof beyond a reasonable doubt. Does everybody understand? So what I can tell you is, again, if you're next door at the civil courthouse, they have preponderance of the evidence. If you are deliberating in any criminal case and someone starts saying, I believe this more likely than not, or that I believe, a percentage that is greater than 50%, then you are not at the correct burden of proof. If you're saying that it's clear and convincing evidence, that's not the burden of proof. The burden of proof in criminal cases is proof beyond a reasonable doubt. Does everyone understand? Notice I said proof beyond a reasonable doubt. So what does that mean? That means if a case were given to you to make a decision on whether someone's guilty or not guilty, you would need to look at whatever evidence that is presented to you, and you would need to ask yourself, do I have a doubt? Is everyone following me? And when I say a doubt as to the elements, right? Then you would ask yourself, the doubt I have, is that a reasonable doubt? This is the hypothetical that some people give. Some people say this, the sun is shining, it's a beautiful day, you check the weather report. There is not a rain cloud in sight. And you're like, this is great. I'm going to go see a movie because it's hot outside. It's Texas. I can go in there. They have AC. You go into the movies. You stay there for an hour and 30 minutes. You come out. The ground is wet. Now, people will tell you, well, it's reasonable to assume that it rained. Does everybody follow my hypothetical? But then you may say to yourself, well, I have a doubt. Then you have to ask yourself, well, what is your doubt? Well, the ground is wet, but all of the cars are dry. Now, did somebody come out here? Because your car is dry, you drove, your car is dry. Did somebody come out here and decide, I'm going to dry all of the cars? And then you start thinking, well, maybe is the sun out? Maybe the sun dried out of the cars. It just didn't dry the ground. But then you see it's still overcast and cloudy. So you may say to yourself, you know what? It is not reasonable to believe that it rained because none of the cars are wet. The ground is wet. So maybe my doubt is reasonable when I think, you know what? Maybe a pipe burst and that's why this ground is wet. But none of the windshields on the car are wet. My car is dry except for the bottom of the tires. The rims are not wet. So you may have a reasonable doubt as to whether or not it rained. Does everybody understand? You may proceed. You have one last question.
Okay. All right, then I guess that would be my last question is who has been a victim or knows someone very close to them who has been a victim of family violence? And if you are, please raise your card. All right. Juror 1, 3, 4, 6, 8, 9, 10, 12, 13, 7, 15, 16, 17, 19, 20, 24, 25, 26, 27, 28, 31, 32, 33, 35, 37, 38, 41, 43, 44, 45, 46, 50, 51, 52, 53, 54, 56, 57, 58, 60, 61, 62, 63, 66, 67, 68, 69, 72, 73, and 74. Thank you all so much. I will thank you all for your time.
Right, defense?
A second, just.
Yes.
Okay. I'll get it.
That's trying to figure out what it's.
Cindy, I'll try to get people to speak up.
It's the bottom one? Yes.
All right. So first off, thank you all for being here. You know, as a defense attorney, all my friends, when they get jury duty, they want to ask me how to get out of it. And a lot of times it makes me upset because they're the type of people that we need here. They're people that can think critically. And, you know, I appreciate that y'all are here because we've been waiting a long time for this. It's a lot of pressure and stress, and we just want our day in court, and it can't happen without y'all. So I appreciate y'all. I want to tell y'all thank you for being here. Now, what do we want in a jury, right? Just want you to tell the truth, right? All we want is a fair trial and for people to take a look at this without biases, without motives. I don't really want anybody that wants to be on this trial. I don't really want anybody that doesn't want to be on this trial. I want people that are just telling the truth and we let the chips fall where they may. And this is not the time to be embarrassed. I mean, if you feel a certain way, be honest, speak up because we deserve a fair trial. The state itself deserves a fair trial. And so all we ask is that you can be fair. And we don't pick it, doesn't mean we don't like you. We're trying to find the right people so that we can reach the right decision on these things. And what a blessing that we have this. I was watching some YouTubes in England. You don't even get a jury. They might sentence you right off the bat. So at least here, when we have disputes over facts, the jury decides the facts, right? Just because someone says something doesn't mean it's true, right? We all agree?
Yes.
Who here has ever heard a rumor? Anyone ever had a rumor about yourself? Right? What do? You want to look, well, what's the evidence to support that? Who's the person saying that, right? I'm going to kind of breeze through these because the judge did a good job of covering these, right? Some people, does anybody in here feels like, well, if I was innocent and I didn't do this, I would get up in front of the jury. Who here feels like that? No one? Number 16, you feel like that? Okay. Who here feels like if I was innocent and I'm accused of something, I'm going to get up there and I'm going to testify and I'm going to tell this jury? Who here feels that way? All right, now keep your numbers up. How many of y'all have ever been in court before and been questioned on the stand? Sure.
I was in court. I was being sentenced for my first WI offense. They wanted to send me away for 18 months. My attorney wasn't saying anything, and I asked the judge to say something. I asked the just put I go to jail, who's gonna pay my child support? Because I see that cycle, I saw it happen throughout the family. Go to jail, out of court, you end up back in jail. So that's why I think I can speak up. To an extent.
Let me ask you, if you trusted your attorney and he's telling you,
I
hey,
did trust my attorney, he was they put it here.
the whole point is that you can't hold that against them, and there's many reasons why. Some people get nervous on the stand sometimes. Your attorney, I mean, as a defense attorney, I don't want hardly anybody speaking on the stand, even if I know they're innocent, just because we don't have to prove anything. Why are you up there? They gotta prove everything, right? We don't even have to talk, like Judge was saying. But you can't hold it against them. You'll go back there, that shouldn't even be a consideration for you. Keep it out of your mind. And if you can't keep it out of your mind, raise your hand right now so we don't put you in that position. Everybody understands you can't. Number 28.
Not understanding the point.
I want to make sure that everybody in here is not going to hold it against him if he doesn't testify. Is anybody going to hold it against him if he doesn't testify? You think he needs to? Anybody else agree with number 28? All right, hold them up. Number 2, number 25, or I'm sorry, number 12, number 25, 27, 28, 29, 42, 51, and 72. That's the Fifth Amendment. You can't hold it against him, right? There's a reason for these rules. There's been a lot of pain and a lot of really unfair things that have happened. And we as a country, this is what our judicial system is, and it's that way for a reason. And I understand some people can't do that, but if you can't do that, I appreciate you speaking up, right? Now, we talked about family violence. It looked like a lot of people raised their hand. I might circle back to that one. Does anybody here think that there's evidence that my client is guilty just because he got charged? Anyone? Right. There is no evidence. Right now, he's innocent, right? He's innocent. And unless and until they provide evidence, and not just evidence, but evidence that you actually believe beyond a reasonable doubt, he stays innocent. So, burden of proof. It's really hard to prove that you didn't do something, right? They have to prove that this actually happened, right? And it's not enough just to throw someone up there. They've got to be, you have to believe them beyond a reasonable doubt, whatever that means to you. We all have life experiences, right? We all know people that have motives, right? We all understand that. We all understand when people lie. So that's why we come to you. That's why you're the determiner of what the facts are, right? Because you get to look them in the eye. You get to use your life experience to say, I don't believe this person, and I do believe this person, right? State has the burden, right? So let me ask you. Juror number 9. So if a witness says that something didn't happen, right? That the crime didn't happen, what must the state prove about that testimony?
Honestly, don't.
Does anybody?
So I'm gonna object this being a misleading question for the jury at this point.
All right, could parties approach, please? And I'll pause your time.
Seven minutes left. You make the determination, right? So I'll just leave that up to you. You get to decide who's lying, who's telling the truth, but they have to actually prove their case. I don't have to prove anything to you, so just keep that in mind. If they prove their case. This is the levels of, different things that get brought to court have different levels of proof that are required, right? So you have your, a reasonable suspicion, right? That might be to pull you over in a police vehicle, right? Probable cause can get you searched, right? These are lower, we're working our way up. Clear and convincing, that's what they use to take people's kids away from them, right? We're talking about levels above that, right? This is a very high standard. It's very high for a reason. Juror number 17, can you tell me why you think it's high? Why we would have a high burden, not a low burden? Why do we have such a high burden that you have to prove it beyond a reasonable doubt? Why would we use one of these lower ones? Clear and convincing, why is that not enough? Why would you want, does anybody have a number 30, number 18? Let me guess.
So I think it's really important to have this in criminal cases because we don't want to be convicting innocent people on more flimsy evidence.
Exactly. This is a very high standard because there's some very serious, and there's a reason, like I said, why we have these things, right? So that's not just something to blow over and blow by. That's a very, almost the most important thing about this, right? They have to prove it beyond a reasonable doubt. Clear and convincing, that's enough to take your children away, right? This is steps above that. Has anybody ever heard of the Potemkin village? So there's a queen in Russia, right? And she's the queen. She wants to make sure everything's going right. So she tells her advisors, I want to get out there and see how things are going. Now, they weren't going very well, right? So they devised a plan. We'll keep her on a train and we'll put up facades and make it look real pretty. And we'll have people out there working. And as long as we can keep her on that train and control what she sees, and she doesn't get off and get around and talk to people, we can fool her. And they did. Till she started to recognize, well, wait a second, I think I've seen these people. I want to get off and go talk to them. And it was all a fraud. Once she started talking to them, she started realizing they're lying to me. It looks like one thing, right? So I want y'all to keep that in mind because the state gets to go first, right? So they're going to have you on this. Just keep in mind, I'm going to get you off and we're going to walk around. We're going to talk about some of those things. But don't make a decision until you've heard everything, right? Because there's a reason why there's a back and forth to this, right? Keep in mind, just because someone says something doesn't make it true. Witness credibility, right? You never met any of these people, right? Has anybody ever met anybody involved in this case? So you have no clue if they're a liar. You have no clue about them, right? So you got to look at the actual evidence that you're seeing. Is there evidence to support what they're saying? Use your brain. Okay, I've seen that. I've heard this. This kind of makes me feel, use your intuition as a human about who's lying to you and look at the actual evidence. Not everybody's a moral person. Not everybody's a good person. Some people lie. Some people will lie to throw you in jail, ruin your life. Keep that in mind. You don't know these people. Wait until we have a chance to speak to them because I think you might hopefully figure some things out about credibility. Who here feels like, first off, anybody in here divorced? Number 7, let me ask you. Would you think your ex would, first off, y'all get along well? Would she be someone you would want up there for the jury to think's credible?
Yeah.
Does anybody have an ex they feel like, or just a person in their life they feel like, I would want number 16? You think she might lie about you, understand? And she's family, right? She was at one point. According to the code, even if you divorce, she's still your family, right? According to the code, for this purposes, she is, right? So sometimes your own family, sometimes especially your own family would lie about you. Would you not agree? Right? Let me ask you, Jonathan, why shouldn't you trust somebody that says they hate you? They say, well, I hate her. And then they talk about you. What would you feel about that? Why would you want to trust them or not trust
I think it could happen again. I mean, if somebody's spreading lies about you, because it's not gonna happen again, whether they continue to do it.
them? Right? So what if someone's lying to you, you don't stop them? And they keep doing this, right? What about if someone controls all your food and your shelter? Does anybody here think that might be a motivation to lie? Just show your cards. Right. It's obvious, right? It's obvious. Sometimes there's obvious motives, and you've got to keep that in mind when they're talking to you. And you might not hear about them till we go. That's why I'm telling you. Keep in mind when you're hearing this, okay, this person might be lying. Okay, there might be motives. They might hate, keep that in mind. Hey, this is something we should all know. If the people around you don't trust you, no one should trust you, right? Don't trust a liar. Especially don't trust a liar that hates people, the person he's talking about. I've heard a rumor, a dirty rumor. I know my friend doesn't like that person. I'm sitting there thinking, hey, well, you kind of hate her. Y'all used to date or what, Keep that in mind. Jury number 10. Who's a more credible person to you? Someone who's calm and helpful or someone who's irrational and hateful? Or do you think it doesn't really matter? Okay, yeah, so that might be something we should look at for our witnesses. Are they trying to manipulate? And emotions are one of the key ways that people, narcissists, people we know, manipulate people. So let me ask you, just so someone's up there crying, does that make them credible? Some people could cry. Tom Cruise probably cried, jump a hat, if you asked him to, right?
Your Honor, I'm gonna object to this slide. May I approach?
Yes.
At this point, I'm going to pass it over to my colleague, Deborah Sanheinrich. Y'all are going to be deciding if this thing even gets to punishment. Y'all are going to be deciding the punishment. So she's going to speak on that.
Well, good afternoon, everybody. Are y'all having fun? All righty, that's what I like to hear, some excitement. So my name is Deborah Sanheinrich. I have been practicing law for too long, man, too long. I'm an old lady. He could be my son. In fact, my son actually works at the firm that we all work at as attorneys. He'll be 43 next month. So that kind of tells you how old I am. And I've been practicing law since before he was born. So that kind of tells you how old I am. I'm talking about punishment in this case. So in every case, in a criminal case, a defendant has an absolute right to decide, and he has to make this decision before the jury is selected, before you even walk into the room as a panel. He has to make a decision as to, if I am found guilty, who do I want to punish me? Okay, and there's two choices, the judge or the jury. Okay, everybody understand that? And so what happens is that we have in Texas what they call a bifurcated form of criminal justice. In other words, you have the first part of the criminal justice system, which is the jury trial that determines guilt or innocence, okay? So that's the first part of the trial. So before we even get to that part, you know, and we're maintaining innocence, we still have to make a determination and let the judge know and potential panel know who we would elect issue punishment if he is found guilty. So we have the guilt innocent phase. So if the jury were to determine that he was guilty, then we go to the second part of the trial. It's kind of like another mini part of a trial. It's like another part of the trial, but we don't have to pick a new jury. It's the same jury, okay? And so then testimony would be presented, evidence would be presented, and then the jury determines whether or not the defendant has an appropriate form of punishment. Now, in this case, my client has decided that if he is found guilty, he trusts you all to assess punishment. Because that's how much faith he has in you and in the system and in the facts of the case. Okay? So knowing that, there is a range of punishment in this case. And there's a reason why in Texas has a range of punishment. Because not all facts are the same in every case. You have heard earlier, the judge gave an example of a murder. Okay, so that's a first-degree felony. And the range of punishments there is from 5 to 99 or life. Okay? So as she gave an example, let me give one. You have a guy who walks into the store and he's just a mean SOB. And he doesn't like the way somebody talked to him, felt like he was being disrespected. You heard that a lot, right? Being disrespected. And it could have been the guy was just like, you know, wow, I can't believe you got chewing gum on your shoe, but okay, whatever. The guy walks out into the patio or walks out of the store, and the dude who felt that he was disrespected goes over and just wails on him and begins to beat him. He beats him to death. Oh, but disrespects, man. Now that's a murder. That's a murder. So you got a range of punishment, 5 to 99 or life. And the jury and during punishment phase could hear testimony about, man, this isn't the first guy he's done this to. The other guys didn't die, but he sure put him in the hospital for a long time. And he's just a mean hombre. Society isn't safe having him out on the street. And they hear this testimony. So they say, well, you know what, man, that guy may not want to be a probation kind of person. So we might want to put him in prison for a considerable length of time. Okay? So that's one kind of, and that's a murder. Now you got mom and pop, man. They've been married 60 years. It's a loving family. They're kind. They love each other. Good people. Their kids, but they themselves are pretty good people, man. And so mom comes down with terminal cancer. And they promise each other, hey, man, if this ever happens to me, I don't want to be hooked up to anything. Disconnect. And so they sit there and they talk about it. I don't want to go through all the pain and suffering, and I don't want to put my family through it. Just disconnect. And so Papa, that's what he does. The nurses go out, they'll go bring some Jell-O and the little nasty ass food that they call at the hospital. She says, I don't want that. And while the nurses out getting the Jell-O, Pop goes and disconnects. That's a murder. Now, would you suffer? Would you think that he would be subject to the same type of, in that range of punishment of going to life for a long period of time? That might be a case that we just say, you know, man, that's probably probation. And in Texas, if you sentence somebody for 10 years or less, he's eligible for probation. Now, probation isn't just something where, okay, you know, slap on the wrist. Sometimes some defendants I've had say, I don't want probation. I'd rather go to jail because they're constantly, you know, monitoring you, telling you what to do, when to do it, how to do it. Okay. So probation isn't simple. It's not an easy task. So in this case, he's charged with a 3rd-degree felony. The range of punishment is from 2 to 10 years and up to a $10,000 fine or both. You can say, hey, I don't want to give him any jail time. I don't even want to give him probation. I'll just give him a $10,000 fine or something less. Or you can say, you know, I don't want to give him a fine, but let's just give him, you know, 2 years. But let's probate. I'll put him on probation for 2 years. Okay? So that's the range of punishment. Now, is there anybody here that doesn't feel that punishment should include probation? Anybody? And it's okay. There's no right or wrong answer. Is there anybody here that might think, well, you know, the facts of this case were such that, well, okay, yeah, technically he might have done it. But I don't even think probation is worth it. Let's just give him a fine. Is there anybody here that thinks that they could not do that? That they don't think that that's an appropriate form of punishment? Just giving them a fine. Fair enough.
All right,
Now, there's one thing that I wanted to go back to.
last question,
Pardon me?
last question. Time
Yes,
has
yes.
expired.
Yes, ma'am. And this is an important part. When we were talking about the defendant's right to remain silent, I want to touch back on that. The reason why it's real important, because I know that there were some of you who raised your hands and said that you would like to hear the defendant testify. And I understand with this gentleman here, God bless you, I understand exactly what you meant by that. But there's a reason why a defendant has an absolute right to remain silent, because he doesn't have to prove anything. You accuse me of something, prove it. You accused me. I didn't do anything. So if you're gonna accuse me of something, show me the money. Prove it. How do you prove a negative? How do you prove a negative? You're saying that I did something, so prove it. So that's why it's important that when you go back, whether or not he testifies, and we don't know at this point, and you don't know at this point. But if he chooses not to testify, he's availing himself of his constitutional rights. You can't hold that against him because he has no burden. It's up to the state. If you're going to accuse me, and that's the highest burden of proof. And there was one young lady that just raised her hand when she says, why is the beyond a reasonable doubt the highest? Because if you're looking to put somebody in prison and you're going to accuse them and take away their liberty, you're going to take away their liberty, prove it. And it's not just, well, I think he might have done it, or possibly. No, it ain't that, man. It has to be, prove it beyond a reasonable doubt. Now, it's not beyond all doubt, it's beyond a reasonable doubt. But ask yourself when you're asking about reason, is it reasonable when you look at the testimony and you look at people's motives? Why are they saying what they're saying? And just because they get up and say, oh, I promise to tell the truth, the whole truth, and nothing but. Yeah. You think everybody that gets up there testifies is telling the truth? Of course not. That's where you use your reason and your common sense.
All right, time.
I believe that you will. Thank you very much, ladies and gentlemen.
All right, ladies and gentlemen, I'm going to have you all wait outside and then we'll call you back in to let you know who will be on this jury. Wait a minute. Everybody's rushing. There needs to be some instructions. Number one, do not take those numbers with you. Leave them where they are. Number two, you are not excused. You cannot leave and go home. We have not released you yet. I am only releasing you to go into the hallway. Does everyone understand? All right. You may step outside.